I'm now on the last page of the Statement of Financial Affairs. And again, you're going to sign under penalty of perjury that you've read all of the questions and that you've answered them truthfully and accurately. Now, you know, in other parts of the tutorial, I mentioned that the way I do your petition, I call you and I put a headset on so I can use both hands to type while I'm filling in your petition. I will then email or fax you a copy. I have found that that is the most efficient and accurate way to do this. You're at home and maybe you need to go into the bedroom to pull out a document to answer one of the questions and all. It's a real relaxed and yet 100% accurate way of completing this. If I had you in the office, what am I going to do? Have you in here for 4 or 5 hours? That wouldn't be comfortable for you. We're not going to be on the phone for 4 or 5 hours, but I think that completing these questions, you need my assistance to do it, but to do it over the phone is the best way to do it. And that way we know if there's some additional information we need to get, then we'll get it. It's not a problem. Within your petition, I am required as your attorney to list how much I was paid. That is a requirement. The court, if you'll read the local court rules, and I'll explain later, they have maximum amounts that attorneys can charge for consumer bankruptcies. I charge, by the way, substantially less than the maximum, so it's not a problem. I am more than competitive with any of your law firms that advertise on TV or your cut rate firms. I'm not going to be the cheapest, but I'm frankly not much more than these fly-by-nights that tell you they'll prepare the petition while you wait. I charge a good fair fee, not over what my services are worth, but the important thing is I prepare your petition properly so that when you get a discharge, it's a discharge you can rely upon. People aren't going to accuse you of lying in your petition or being inaccurate or you losing your house or losing your car or something because some stupid-ass attorney didn't know what he was doing. I have seen all of those in my career as an attorney. Again, there's a lot of attorneys that just buy computer software and they're just filling in the screen. They have absolutely no insight into the bankruptcy code. They've never read the bankruptcy code. They've never read the bankruptcy rules. Well, if you get one of those crazy people, then you have a possibility of having some problems in your bankruptcy. I don't mean to scare you, but you know, just because somebody has a law degree doesn't mean they've got enough sense to walk across the street. Disclosure of compensation, that's just the second page. This is where I sign and say, yeah, this is what I was paid. Now, if you notice during your bankruptcy petition, we never listed your full Social Security number. So this document, we're going to file this with your bankruptcy petition, but it's not going to be made public. The court will keep this one for its own records, listing your full Social Security number. Now, mailing matrix. Nobody, I don't know of anybody other than outside bankruptcy that uses the word matrix. All that is a listing of all your creditors. One of the files that I'm going to turn in with your bankruptcy petition is just a simple listing of all your creditors and their addresses so that the court will know where to mail the notice of the bankruptcy. And you are verifying in this matrix that you've listed everybody that you know about. Now, when we list people that we want to have notice of your bankruptcy, if you'll read or listen to the rest of the series, who do I want to notify? Well, I want to notify, let's say you had a Bank of America credit card. Well, I certainly want to notify them. But if they have 4 collection agencies out after you, then I want to list those collection agencies too, so that you're not bothered by them again as much as anything else. I want all your phone calls to stop and all the collection letters. Once they get notice that the bankruptcy's been filed, then they can't call you. And if they do, there are penalties available that you and I can recover from a creditor that doesn't want to leave you alone. All your major creditors are going to leave you alone because they know what those penalties are. It's only the crazy guy down the street that you owe $200 to and he thinks he's got a judgment against you, and he doesn't care whether a bankruptcy petition's been filed or not. That's the kind of guy that won't listen to the notice or adhere to the notice. Well, if we have him picked up by a U.S. Marshal, he'll notice real quick. And that's what we can do. So, don't be worried about it, but we need to list everybody. Chapter 13, Plan and Summary. I put this in here because the Western District of Missouri has an excellent, absolutely excellent standard plan that you and I will fill out if you're in a Chapter 13. So if you're going to do a 13, when you get these downloads from me, take the time and study this. Now, again, you don't need to know how to fill this out. I'm going to fill it out for you. But a couple of observations I want to make to you that, at least on a preliminary basis, you need to know about. The creditors are paid in order of priority. Who's deserving of the first dollars and the second dollars and all. But priority claims, there's a couple of things I want you to be aware of. Priority claims, domestic support obligations. If you were in Chapter 13, if you have a delinquent arrearage on your child support, or if you owe taxes, certain kinds of taxes to federal or state governmental agencies, then one of two rules is going to have to come into play. One, we're going to have to repay that arrearage in full within the term of your repayment plan. So if you owe a former spouse delinquent child support, the entire amount of the delinquency will have to be repaid within the term of your bankruptcy. Or we reach agreement with your former spouse that not paying her the full amount meets her approval. We can do it either way. The same way with your state and local governments. Let's say that you just don't have enough money coming in to pay your taxes in full during the term of the bankruptcy. Well, in that case, I very frequently will get a hold of the IRS or the State of Missouri Department of Revenue and go through your income and expense, and they'll agree, well, he doesn't have to repay it. We've worked out an alternative arrangement with him. But that's part of what we're going to do. Now, preliminarily, let me just mention a few things about Chapter 13 so that you can understand how it works. If you're delinquent on your house payment, we're going to make your regular house payment and then your pro rata part of your arrearage. If you'll go through the videos here, I explain how Chapter 13 works with the numbers. But if you're not delinquent on your house payment when we file your Chapter 13, then you don't have to include your house payment within your Chapter 13. Let's assume that you have a car loan. You're delinquent on your house. So we're going to use Chapter 13. You're going to make up your regular payment on your house, and then we're going to pay a small part each month to catch up on the arrearage. Well, in a Chapter 13, you have to pay all your personal property secured loans through the Chapter 13 plan, whether you're current or not. So if you've got a car loan, that car loan is going to be paid through the Chapter 13, whether you are or are not delinquent. So those are not problems, but I want you to be aware of it. A lot of people will come in here and they've got their car loan set up where it's taken out of their paycheck. Well, it's not going to be that way. We're going to change that into Chapter 13 so that it's paid through the bankruptcy court. Not a major problem, but I just want you to be aware of it. So read through this. It's not self-explanatory, but you and I will go through a great deal of time in drafting your Chapter 13 plan. I'll draft it, email it, or fax it to you. You'll look it over, and then we'll make any changes or additions that we need to do. You may have a loan. Let me give you an example. Let's say that you show up on your sister's loan. She's living in a house and you're on that note too, but you never make those payments. But yet you're a named debtor on that loan agreement. Well, down at the bottom of your Chapter 13, where we put other provisions, we need to tell the court and the trustee that, hey, I'm not going to make that payment because somebody else is making it. So there's a reason for every one of the parts of this Chapter 13. Once you see me complete yours, you're going to understand everything. The good thing about it is at least on this opening, I can show you what a Chapter 13 plan looks like.